scheme is. This scheme is introduced by the Ministry of Corporate Affairs by its circular number 12/2020 dated 30th March 20. So intent of this scheme is give one opportunity to the defaulters to file all the pending documents within a specific period, and condone the delay and immunite the corporates for any proceedings, penal proceedings and prosecutions. So this is the intent to reduce the compliance burden also. And second thing is, for the non-compliant companies, non-active companies also, there is an opportunity to file these documents, related documents, and avail the facility which is given for the striking of the name of the company. What is the benefit of the company? This scheme is condonation of delay. Number 2, one-time waiver to the companies and its officers from prosecution or proceeding for the penalty imposition of and the imposition of the additional fees, and withdrawal of all the proceedings of adjudicating authorities with respect to the penalties under section 554. Means if registrar has already initiated some proceedings before the start of this scheme, and now under the scheme company files all the related documents, then ROC will withdraw the proceedings against the company. This scheme is applicable to a defaulting company who has defaulted in form on their due dates. So under this scheme, a defaulting company can file belated documents with irrespective of their due date of filing. Means defaulting company can file any document of any period. It means even before the Companies Act 2013, if you have not filed any document with respect to the prior to 2013, you can file under this scheme and get rid of all the penalties, and the condonation will be given to you. So for that purpose, defaulting company has been defined by this circular, and it means a company is as defined under Companies Act 2013 and has made default in filing of any or other documents, whether it's a statement, return, etc. So this company is applicable for a defaulting company for default in filing the forms, returns, or the statement, or any other documents. Initially, this company is defaulting company can file in all 64 documents. These are listed and it is available on the MCA website. On the face of the website, list of the documents can be filed under this scheme. So in all 64 forms can be filed under this Companies Act, including 10 forms under 1956 Act. So 54 forms in 2013 Act and 10 forms under 1956 Act. These forms can be filed under this scheme. Some of the forms which are important forms which I am just referring, one is event-based, that is an INC 22A for active company, then 20A, declaration of the commencement of the business, return of allotment, page 3, ADT 1, appointment of auditor, ADT 3 is also included for the resignation of the auditor, MDT 14, filing of the resolution and agreement to the registrar, DIA 12, particulars of the appointment of a director and the key managerial person and change thereof. Tier 11 also is included form. Second is annual base form. These are very important two forms, and majority of the default in these forms also. One is annual return MGT 7, financial statement AOC 4. So these forms are included, and members may go to the MCA website and see what are the details of the 64 forms. Here, there are the two forms specifically are not included, thereby that these two forms cannot be filed under this scheme. One is increase in authorized capital, decrease in authorized capital, say consolidation of the capital. SH7 cannot be filed. It is not covered under this scheme. Second kind of form is CHG1, CHG4, CHG8, and CHG9. All these forms cannot be filed under this scheme because these are not covered under this circular. What are the timelines for filing of these forms? Pending form, defaulting company can file these forms from 1st April 2020 till 30th September 2020. Filing, first company has to file these forms, then filing of e-form CFSS 2020 means after close of the scheme and after ROC take on these forms on record, within 6 months from the closure of the scheme, the defaulting company has to file this form. Therefore, this 31st March 2020 is the timeline for filing CFSS 2020. What is cured? Only one default is cured under this scheme, delay pertaining to the filing of belated documents. Members may please note, this scheme covers only the provisions for the panel provision which will not be attracted to the companies, only related to the delay of filing of the forms or returns. It is not for non-compliance or violation of any other provision of the Act. Under this scheme are there. One is there is no additional fees is required to be paid. Only normal fees are required to be paid on the belated documents, and then immunity will be granted to these companies. Immunity means the ROC shall not make any panel proceedings or prosecution proceeding for non-filing of the form or delay in filing of the forms. One important thing is this form CFSS 2020 is to be made after all forms are filed, and then in case company has already filed any appeal against the order passed by adjudicating authority or prosecution is pending against which company has filed the appeal and appeal is pending for adjudication in respective court or tribunal, then to avail this immunity, company has to withdraw this appeal immediately, and before filing of CFSS, company has to withdraw this appeal, and evidence to show that company has withdrawn this appeal is to be enclosed along with the form CFSS. Then after receipt of the form, ROC will issue the immunity certificate. This immunity is not available in few cases. Number one, if penalty is imposed by any adjudicating authority on delay of filing of the document and appeal is still pending before any court of law, then this immunity will not be available. Or company can file an appeal has been filed, and appeal can be withdrawn before applying for the immunity and filing of CFSS form 2020. Number two, where management dispute pending before the court of law or the tribunal. In the companies where dispute between the directors, dispute between the shareholders are pending against before any court or tribunal, then immunity shall not be available to these kind of the company. However, they can file the forms under this scheme without any additional fees, unless and until there is no stay by any the same court or the tribunal for filing of this form. Third is companies which are convicted in any matter by the court and company has not filed the appeal. One special provision has been also been given where the company's officers against whom auditor this court have passed some orders, and these companies could not file the appeals till date, till the start of this scheme. Then provision says if due date of the filing of appeal is between 1st March and 31st May 2020. If please note it, if due date of filing appeal is between 1st March 2020 and 31st May 2020, then additional 20 days will be allowed to these companies to file an appeal. Before initially, only 60 days is allowed to file any appeal against the order. And in this case, if any order has been passed against the company and company could not file the appeal, now under this, during the currency of this scheme, the due date of filing appeal is between 1st March to 31st May 2020. Then additional 120 days will be allowed to file the appeal, and the ROC will not take the prosecution, will not initiate the prosecution during this additional period of 120 days. Therefore, this is also one opportunity. If company has failed to file the appeal and a due date is between March and May 2020, then these companies can file the appeal for another 120 days from the due date. Effect of the immunity is if defaulting company files the documents and then file the CFSS 2020, and then ROC shall withdraw all the prosecution proceeding under the adjudication, and no further action will be taken by the ROC against the delay in forms filed under this scheme. There are some exemptions, and there are some this scheme is not available in some cases. One is vanishing companies. If companies are vanished companies, they are not available, their whereabouts are not there, directors are not available, and this for these vanishing companies, this scheme is not available. Second is if any company against which ROC has issued a final notice of striking of the name under Section 248 of the Act, and for the striking of the name from the register of the companies. Please note, this exemption is only for the if final notice has been issued. Under Section 248, ROC has to issue 3 notices. One show cause notice, second reminder, then final notice. If show cause notice has been issued to the company and no other notice has been received by the company, by the ROC, this scheme is available. But if final notice has been issued by the ROC under Section 248, then this scheme is not available. Third is company which have already suo moto have filed STK2 for striking of the name of the company of the ROC. See, companies can suo moto go for the striking of the name if company has already filed the STK2 for striking of the company with ROC, then this scheme is not available. But in case for these kind of the companies, if STK2 has been filed, but it is not so far strike off, it is under a process, then the company can take some effect for this defect in the forms, and for that purpose, cancellation of STK2 can be explored and scheme can be availed. But straightway, there is no way if STK2 has been filed by the company and this scheme is not available. Then fourth is companies which have been amalgamated with any other companies, then documents cannot be filed. Fifth is if companies have already filed an application for obtaining dormant status under section 455. 455 says if directors of the companies are of the opinion, then company is not doing the business at present, but in future they can do the business, or they are not doing any, means they are not filing, they have not filed the annual returns and the balance sheet for the last 2 years, then companies can apply the ROC for the dormant status of the company. But dormant status of the company can be, dormant can be given, status can be given for maximum of 5 years. Then for filing of the form relating to, as I already discussed, that increase in authorized capital and the forms relating to the charge, registration of charge and satisfaction of charge, this scheme is not available. So to sum up, this scheme is not available for vanishing company, the companies which have received the final notice from the ROC, the company which have already filed the STK2 for the striking of the name of the company, company which have been amalgamated, company which have already filed an application for obtaining dormant status under section 455, filing of the forms relating to the increase in capital and charges. This scheme, as I initially told, that for the inactive companies, this scheme is very, very important. See, the companies which are not doing any business for the last so many years, companies which are defaulted in filing so many forms for the last so many years. So for that companies, if I go for the presently before start of the scheme, if I go for the striking of the name, then I have to file all the documents, pending documents for the previous years and pay the huge penalties and additional fees. Now, these kind of the companies have two options. One is first file all the belated documents with registrar of companies without any additional fees. Only normal fees can be filed, and then apply to get themselves declared as a dormant company under section 455, filing the form with a nominal fee. Second option, company can file these documents and then apply for the striking of the name of the company by STK2 by paying a fee payable on the STK. This is the warning. Warning means if any defaulting company is failed to avail this scheme and file the all belated documents after closure of the scheme, those companies who have not availed these facilities of this scheme, ROC shall take all penal action as per the provisions of the law. This is all about the CFSS scheme. So friend, this scheme is also the intent of the scheme for the LLPs also there same. LLP also we have seen, we have not, LLPs have not filed so many documents, means people are not, sometimes initially people were not aware also the filing of the agreement, appointment of the partners, designated partner, resignation of the designated partners, balance sheets, financial statements, that all. So this scheme is given again a very good one-time opportunity to the LLPs to make default good for filing of the prosecutions, and the immunity will be granted for the legal penal action by the ROC. Benefit is condonation of delay, no prosecution and proceedings, no penalty or additional fees is required to be paid. Any defaulted, here there is a difference of CFSS and this LLP scheme is, in CFSS there is no limit of the due date of the documents. All the documents till even 28th of September can be covered under that scheme. But here in LLP, the defaulting LLP can file the belated document due date, whose due date is filing till 31st of August. Up till 31st of August, whatever documents are due, LLP can file these documents. And defaulting LLP means the same LLP registered under the LLP Act 2008, which has made default in filing the documents on due date. See, as per the circular, only 4 forms are mentioned, but as per the website of the MCA website, 12 forms of the LLP are included in this scheme. Form number 3, few important forms I am just referring, otherwise 12 forms are covered. These are also available on the website of the MCA. Form 3, LLP agreement. Form 4, notice for the appointment of the partner or resignation of the partner or the designated partner. Form 8 is statement of accounts and solvency. Form 11 in annual return. So these forms are covered under this scheme. Timeline is the same between the 1st April to 2020 to 30th August, September 2020. But in this case, documents which due on for filing is 30th August 2020 can be filed. Default can be cured, only delay pertaining to the filing of the belated documents can be cured. Immunity is available to defaulting LLPs which shall file their pending documents, and no prosecution proceeding shall be initiated by the ROC for the default and delay in filing the belated documents. The scheme will not be applicable for filing of the documents. As per the circular, only 4 documents were mentioned, but according to MCA website, 12 documents will be covered under this scheme, no other documents. And second is LLP which have already filed Form 24 with the registrar for striking of the name of the LLP, and then the same LLP cannot be availed this scheme. Action after the closing of the scheme, this is the same. If after the closing of the scheme, if LLP is not availing this scheme, the ROC will take, the registrar will take the suitable action, penal provision and prosecution under the Act. 2 things I want to just refer for both the companies, both these schemes. One is the immunity is available only the provision related to the delay in filing the documents. No other provision under the Act. I give the example. One example is if company has not filed the PAS 3 for the return of allotment. So by filing PAS 3, the immunity will be granted for delay in filing PAS 3. But if according to the provision, the company is required not to use the money of the application till the PAS 3 is filed. If there is a default in that portion, that default will not be cured under this scheme. Or example I can give, annual return. If filing of the annual return is delayed, then it is covered under the immunity. If company has failed to convene the AGM and therefore filing of the return is not there. So failing in convening of the AGM is not covered under this immunity. But filing of the delay in filing of the form is covered under this scheme. With this, I'm closing this